In medieval Europe, pigs had lawyers. Not metaphorically, literally. A sow accused of killing an infant would be assigned a court-appointed defense attorney, housed in a jail cell, formally indicted, and tried before a trained judge using the same procedural law applied to human murder cases. If convicted, she would be dressed in human clothing and hanged by a state executioner at the standard rate. This happened not once, not twice, but at least 12 times in France alone. And France was not even the worst offender. For over 1,000 years, across 13 countries, the most sophisticated legal minds in Western civilization put animals on trial. The question is not why they were so primitive. The question is why they were so deliberate. To understand how a pig could stand trial for murder, you have to understand what medieval European law actually believed about the universe. In the 13th century, trained jurists, men who had studied at Bologna and Paris, who had read Aristotle and Aquinas, argued that God had established a single moral order governing every creature on earth. The source was Genesis, chapter 1, verse 28. God gave humanity dominion over the animals. But dominion, in medieval legal thinking, was not a one-way street. It meant that animals were bound into the same moral fabric as human beings. They were not objects. They were participants. Participants who could sin. Participants who could be held accountable. An animal that killed without being punished was not just a danger. It was a cosmic insult, a hole in the divine order that, if left unplugged, would invite further chaos, further divine anger, further catastrophe on the entire community. The law was not punishing the pig for the pig's sake. The law was repairing a tear in the universe. Back to fillets. The facts of the case are these. A sow, roaming free as pigs routinely did in medieval towns, entered a home. Inside, an infant had been left unattended in its cradle. The sow attacked the child and inflicted wounds severe enough to kill. This was not unusual in medieval Europe. Pigs wandering through streets and into homes was a common feature of daily life, and infant attacks were a known and documented hazard. What happened next, however, was not routine at all. The sow is taken into custody. She is housed in the local jail, in a cell. A formal criminal indictment is drawn up, using the identical legal language applied to a human suspect. A defense counsel is appointed to represent her interests in court. Witnesses are called. Evidence is presented. The judge deliberates. The procedure is not improvised. It is not symbolic. It is the same step-by-step process that the same court uses every time a human being is charged with homicide. Every procedural protection that exists for a human defendant is extended, in full, to a pig. The verdict, guilty. The sentence, death. But not simply death. The Court of Fillets is precise about what justice requires here, and precision is the point. The sow is dressed in human clothing before her execution. A tunic, a coat. This is not theater for its own sake. This is procedure. Animals convicted of capital crimes in medieval Europe were dressed as humans because the punishment being administered was a human punishment. The state executioner, the same man who carries out human executions, is paid 10 sous and 10 deniers for his services. The official rate, the rate on the books. Before the hanging, the executioner mutilates the sow's snout and forelegs to mirror the wound she inflicted on the infant. This, too, is specified by the court. The entire town of Fillets is required to attend. Not invited. Required. Because justice, in this system, is not a private administrative matter. Justice is a public performance, and every citizen is both witness and participant. The message delivered to everyone watching is clear. No act of violence, anywhere in this town, exists outside the reach of the law. The Fillets pig was not an aberration. She was not the product of one eccentric judge or one overwrought community. She was one data point in a continent-spanning legal practice that lasted over 600 years. In 1906, an American scholar named E.P. Evans published a meticulous study titled The Criminal Prosecution and Capital Punishment of Animals. He had spent years combing through court records across Europe, France, Germany, Switzerland, Italy, Belgium, and what he found was staggering. 191 separate documented animal trials, cases from 824 AD through to the year of his own publication. 13 countries, hundreds of judges, hundreds of defendants who could not speak in their own defense. Pigs were the most frequently prosecuted. They accounted for roughly half of all secular animal trials. At least 12 separate pig executions are documented in France alone between 1266 and 1572. Historians had not overlooked these cases. The records were there, in the archives, waiting. What evidence showed was that this had never been fringe behavior. This had been mainstream European legal practice, running in parallel with everything else medieval civilization produced. Its cathedrals, its universities, its philosophy, its art. Around 1508, in the Burgundian town of Autun, the local authorities face a crisis. The barley crop has been devastated. The culprit is identified, a colony of rats that has been systematically destroying the fields. The town brings a formal criminal case. The rats are charged with felonious destruction of property. And the court does something remarkable. It appoints them a defense lawyer. His name is Bartholomew Chassaigny. He is young, trained in canon law, and he takes the assignment with complete seriousness. Chassaigny does not appear before the court and gesture helplessly. He files motions. He raises procedural objections. He argues the law with precision and authority. Most people who know this case remember it as a comedy. The absurdity of a lawyer defending rats. What they miss is the follow-up. Bartholomew Chassaigny's reputation for legal brilliance grew so dramatically from this case that he eventually became the president of the Parliament of Provence, one of the highest judicial offices in all of France. His animal defense work was not a career embarrassment. It was a demonstration of skill that a sophisticated legal culture recognized and rewarded. Chassaigny's first argument was this. Individual summons had been served to some of the rats, but the rats were dispersed across multiple villages throughout the Autun region. A summons served to one rat in one village did not constitute adequate notice to the entire colony. New summons would need to be issued, broadly, across every village in which the rats resided. The court agreed. When the rats still failed to appear at the rescheduled hearing, Chassaigny returned with his second argument, and this is the one that stopped the court completely. His clients, he explained, had every intention of appearing, but the roads between their villages and the courthouse were patrolled by cats. To compel the rats to travel those roads was to compel them to risk their lives in order to attend their own criminal trial. This was a legal impossibility. The court had a prior obligation to guarantee the safe passage of any defendant summoned before it. Until that guarantee could be provided, the rats could not legally be required to appear. The case was never resolved against the rats. Chassaigny's arguments are documented in his own published legal writings, the Concilium Primum, cited in law schools for generations afterward. Not as a curiosity, as jurisprudence. Secular courts handled animals accused of crimes against persons. Ecclesiastical courts, the courts of the church, had jurisdiction over a different category of case. When crops failed, when plagues of insects descended on a diocese, when fields were consumed by weevils or caterpillars or locusts, the church had its own legal remedy. Not execution, excommunication, the anathema, a formal ecclesiastical curse, issued with the full authority of the bishop, legally binding under canon law. In 1478, a tribunal convened in Bern, Switzerland. The subject of the proceeding, a swarm of caterpillars that was systematically devouring the agricultural holdings of the diocese. The court issued a formal order. The caterpillars were given 3 days to cease their destruction and vacate the diocese. If they failed to comply, they would be placed under permanent excommunication, cut off from the grace of God and the protection of the church for eternity. What is striking about this case is not the outcome. It is the administrative machinery behind it. The court that issued this order was the same court that tried heretics, dissolved marriages, and adjudicated the spiritual welfare of hundreds of thousands of human souls. It used its most powerful weapon, not against a human sinner, but against insects. The most extraordinary outcome in all of medieval animal law did not end with a punishment. It ended with a settlement. The town of Saint-Julien in Savoy took the Weevils, destroying its vineyards, to court twice. First in 1545, the Weevils failed to appear, the case dragged, and was eventually set aside. Then in 1587, Saint-Julien tried again. The second trial lasted several months. Both sides presented genuine legal arguments. The town's lawyers argued for the destruction of the weevil population or their permanent expulsion from the vineyards. The Weevils' defense argued that the insects, as God's creatures, had as much right to the produce of the earth as the humans who claimed to own it. The court deliberated, and then it ruled in favor of the Weevils. Not a conviction, not an acquittal, a settlement. The Weevils would be granted a separate plot of land outside the vineyards as their legally recognized feeding territory. In exchange, they were expected to confine their activities to that parcel. The town accepted the terms. The court recorded the agreement. A negotiated land settlement between the municipality of St. Julien and a colony of insects stands in the Savoyard court records to this day. 1750. Vanvres, France. A man and a donkey stand accused together before a criminal court of a capital sexual offense. The charge carries the death penalty. The man is tried, convicted, and condemned. The donkey faces identical proceedings, the same charge, the same court, the same potential sentence of death. But then something happens that cuts to the heart of everything this system believed about itself. The local parish priest submits a sworn affidavit to the court. He has known this donkey for years. He attests to its virtuous character, its gentle nature, its blameless conduct throughout its life. Several respected citizens of Vanvres follow with their own sworn depositions, corroborating the priest's testimony. The court reviews the character evidence. The court deliberates. The donkey is acquitted. The man is executed. This was not a miscarriage of justice. This was the system functioning exactly as designed, evaluating the moral character of a defendant and returning a verdict based on the evidence. The same evidentiary standards that could send a human being to the gallows had just, formally and officially, cleared an animal of a capital charge. The line between the two had been drawn, in a court of law, by sworn testimony, and the donkey was on the right side of it. Animal trials were not evidence of ignorance. Scholars who have studied them most carefully, legal historians, medievalists, philosophers, consistently arrive at the same conclusion. These proceedings were evidence of something far more sophisticated than ignorance. They were evidence of a society that needed, at the deepest level, to believe that the universe was governed by rational, comprehensible law, not chaos, not arbitrary divine whim. Law. A pig that could be hanged was a pig that had been judged. A rat that could be summoned to court was a rat that existed within a legal order. A donkey that could be acquitted on character evidence was a donkey whose innocence had been formally established. The French philosopher Michel Foucault spent years analyzing why European societies performed public punishment the way they did. His conclusion was stark. The spectacle was the message. Public execution did not merely punish the criminal. It communicated to every witness that the power of law was total, visible, and inescapable. Medieval animal trials extended that message beyond the human world entirely. No creature, no force, no disruption of order, anywhere in God's creation, existed outside the reach of the law. That was the claim. And for 600 years, European civilization believed it. In 1906, an American scholar named Edward Payson Evans sat down and published the definitive record of everything we have been describing. His book, The Criminal Prosecution and Capital Punishment of Animals. Evans had spent years tracking down court records, ecclesiastical proceedings, and legal manuscripts from archives across 13 countries. What he assembled was the most complete account of animal trials ever compiled. 191 documented cases, spanning more than 1,000 years of legal history, from 824 AD through to his own time. The book is meticulous, dry, and deeply strange to read. Evans catalogs pig hangings and rat summons and weevil settlements with the same scholarly detachment he would apply to any other body of case law. He treats it as what it was, a legitimate area of legal history that had been overlooked because it was embarrassing, not because it was unimportant. What Evans could not have known, as he finalized his manuscript, was that the very same year his history of the practice was being published, the practice was ending. In Switzerland, in 1906, 2 dogs were formally tried and executed for allegedly assisting in a murder. Evans' history of animal trials and their final known instance exist in the same calendar year. He documented the end of a 1,000-year legal tradition without knowing he was doing it. Here is the thing that stays with you, long after the absurdity has worn off. The same courts that hanged the fille's pig also hanged human beings. The same judges who listened to character witnesses for a donkey sentenced men and women to death by burning. The same legal system that negotiated a land settlement with Weevils was the legal system that conducted the Inquisition. Medieval animal trials did not exist alongside the human justice system as some strange parallel aberration. They were the human justice system, extended, with perfect internal logic, to cover every creature the medieval mind believed to be morally accountable. The line between who could be prosecuted and who could not was not a line between human and animal. It was a line drawn by law, and lines drawn by law are always drawn by whoever holds the power to draw them. Today, corporations hold legal personhood. Rivers in some countries have been granted legal rights. The question of which entities count as persons before the law, which beings can sue, be sued, be protected, be prosecuted, is not a settled question. It has never been a settled question. Medieval animal trials remind us that every answer that civilization has ever given to that question has eventually looked, to the people who came after, somewhere between bewildering and monstrous. Medieval animal trials ran for over 1,000 years. They crossed the entire continent of Europe. They involved trained lawyers, senior judges, formal court records, and published legal treatises. They did not end because people woke up one morning and recognized the absurdity. They ended because the theological and legal framework that made them coherent, the framework that placed every creature under a single divine moral law, slowly collapsed under the weight of the Reformation, the scientific revolution, and the Enlightenment. The practice did not die of embarrassment. It died when the worldview that justified it died. Every civilization has a worldview. Every worldview produces a legal system. And every legal system, when viewed from the outside, from a different century, a different set of assumptions, contains something that will look, to that outside observer, exactly like a pig in a defendant's dock. History's hidden chapters exist to find those things. The buried cases, the forgotten precedents, the stories that were too strange, too uncomfortable, or simply too obscure to make it into the standard account. If that is the kind of history you want, subscribe. There is no shortage of material.